Thank you. We just approved the April meeting minutes. All right, now we go to a very important work that's that has been, oh, I'm sorry, Patty, we're going to wait on that. I believe Dean Rooksby is with us and he needs to go. So we're going to adjust our agenda today to accommodate Dean Rooksby from Gonzaga Law School. I'm an adjunct there, so I have to listen to my boss. I'm sorry, everyone. So Dean Rooksby is here to update us with what is going on at Gonzaga Law School. Dean, over to you.
Thank you, Francis. Can everyone hear me okay?
Yes.
Yes.
For some reason, I cannot get my video to work. And as you might surmise from my voice, I'm losing my voice, which is not a good place to be in as we prepare for commencement tomorrow. So I just wanted to give a few updates about some of our initiatives and some of our progress here at the law school. 4 years ago, when I started this position, the diversity of our student body was around 13%. It has now grown to 27%. It's been 25% or above the past 3 years. And we're proud of this, but we still have more work to do. I want to talk about some of the initiatives that I think have led to this growth in the diversity of our student body. One, we've created a full ride scholarship program named after Frank Burgess, who was a Black alum of the law school and went on to be a federal judge. Incidentally, he was also the all-time leading point scorer on our men's basketball team. And the focus of that scholarship is really to recruit a talented, diverse student to our law school with no strings attached. So it was the first scholarship of its kind that is a full ride where diversity is a criterion and academic excellence is an expectation. Many of you are probably familiar with our longstanding Thomas More program. We had some very difficult discussions related to the name of that program in the past couple of years. And we decided to change the name to honor not a white saint who doesn't have a connection with our law school, but instead Karl Maxey, a legend of the bar here in Eastern Washington, a Black man who fought for social justice and has an enormous amount of accomplishments to his name. Now, when students seek to learn more about that scholarship program, they're going to learn more about Karl Maxey. That program has 3 slots, and we look for not only academic excellence, but diversity is now a stated criterion, and also a commitment to furthering social justice. So we are now approaching our 2nd year of having that program, and we have 3 full ride scholarships as part of it. The Thomas More program has shifted to a program that provides financial awards to students in the summer after their 1L or 2L year, if they are engaging in work that furthers the public interest for which they are not paid. They're able to apply for and obtain Thomas More scholarship grants in the summer. We have also launched into a pay equity for our faculty. So when I arrived, I quickly noticed that our faculty were not being paid equitably across gender lines in particular, but also I felt some other ways as well that merited adjustment. So we've made those adjustments. I think it's an important signal to those faculty as a way to retain them and pay them fairly, of course, which we're proud to now be doing. We also have launched 2 new clinics that have generated a lot of notoriety and interest from our prospective students and our entering students. The Lincoln LGBTQ+ Rights Clinic, which is the first of its kind from a Catholic law school in the country, and one of only a handful that exists in the country. We also have our Catholic Charities Immigration Clinic, and both of these have been really oversubscribed. The interest is strong amongst our student body. This has led to beneficial change at the law school in other ways as well. So the signaling value of having the Lincoln LGBTQ plus rights clinic has been immense to our students who perhaps identify as LGBTQ or allies of LGBTQ communities. So this has led to us changing on our application and asking additional questions related to gender identity and expression and sexual orientation, things that before we did not have on our application. These are optional, but we learned quickly that we cannot improve what we do not know or we do not track. So we have entered an era where we have additional data about the uniqueness and the diversity of our student body so that we can preemptively help support students as they come into our community. Just this past spring, we announced the elimination of conditional scholarships. This to me has been a work in progress over many years to get to this point to be able to do this. And to tell people what those are, in case you're not familiar, at our law school for about the past 20 years, every offer of admission came with effectively strings attached. It was conditioned on maintaining a minimum GPA of 2.75. We knew because of the mandatory curve in the 1L curriculum that anywhere from 25% to a third of our students would be unable to maintain that minimum GPA in a given year, in which case they lost their scholarship when they became a returning student the next year. This practice needed to end for a lot of different reasons. It impacted disproportionately students from disadvantaged communities, first-generation college students, students facing hardship of any kind in their life, whether it was a family health matter, any number of things. And if you think about trying to recruit somebody to come live in Eastern Washington who may have, maybe not be from here and be a little bit on the fence of whether or not they should move, well, this was an encumbrance. This was something standing in their way, particularly as they received offers that were not conditional from other law schools, perhaps law schools that were closer to home. So we announced this past spring to all of our current students that their scholarships are no longer conditional. And for all entering students going forward, we have guaranteed scholarships for the duration of their time with us. We have already heard from many students the impact this announcement has made on them. We've heard from alumni and their support of it. And we are seeing that students who before may not have chosen Gonzaga Law School are now choosing us. Finally, I want to mention about our new faculty. We are a small faculty of 24. We now have 8 full-time faculty members who are people of color or bring international diversity to our faculty, 33%. That number goes to 38% if we include fellows in our Center for Civil and Human Rights and our Center for Law, Ethics, and Commerce. If we looked at the composition of our faculty just even 4 years ago, that number was at 12%. So we've made real headway. We have had an opportunity to recruit faculty to our law school, which is a great thing based upon planned retirements and natural turnover. And as we've done that, we've prioritized diversity and looking expansively in who we bring to our law school. We're particularly heartened. Some of you may be familiar with Professor Jeffrey Omari. He was a fellow in our Center for Civil and Human Rights for 2 years. He successfully landed a position at Northern Illinois University College of Law, where he taught for 2 years. He wrote an article for the ABA Journal that talked about his experiences being a Black man teaching in Eastern Washington at Gonzaga Law School. It generated a lot of attention. This was pre-George Floyd. And he discussed the difficulties of living here and being here and interacting with students who may come from different communities that are all white and bring their own perspectives into the classroom. That article got a lot of attention. A lot of people thought it was negative attention. we used it as an opportunity to double down on the problems that he identified. And we're very heartened and excited to say that Professor Omari is coming back to Gonzaga Law School this fall as a tenure track professor, leaving Chicago, which is obviously a much more diverse community, and his home region. He missed Gonzaga and wanted to be back here. So we're very excited about that. I am rapidly losing my voice, but I have covered the main items I wanted to share with you all. I apologize, I cannot get my video to work for some reason, but I welcome your questions and thoughts and feedback.
Thank you, Dean Rooksby. Any questions, comment for Dean Rooksby? Terry, go ahead.
This is Terry Price. I'm one of the ATJ board members, but as many people know, my day job is at the University of Washington Law School. I won't make you respond because you're losing your voice. I just wanted to say congratulations on the Lincoln LGBTQ clinic. I just looked it up on the website, and it's in good hands with Professor Gail Hammer.
Thank you, it certainly is.
I echo that too. All right, anyone, any other comment? Yes, SP.
I just wanted to say that your leadership is much appreciated. That was a bold move to change the one program that you have to reflect Carl Maxey's name, the Thomas More program, and change that to Carl Maxey, somebody that we're familiar with and who's done so much. And I thought that was a pretty bold move to make, and the right move to make. So Gonzaga just went up a big notch for me.
Wonderful. Well, thank you. And I will say that was a very challenging decision, and not one that was widely supported by some of our prominent Thomas More alums.
Mm-hmm.
However, the founder of the program very much was in support of the change. And I think that meant a lot to some of our alums. Professor John Maury-Maurice. And he conceptualized the program back in the day and told me that he named it after Thomas More because he knew the university would then support it. But he had already committed full ride scholarships before they had even supported the concept of the program. So although he had attachment to the name, he also very much believes that programs ought to change to fill the needs of the time. So I'm very pleased that we had his support in making that name change. And now when students learn about that program, they're learning more about Gonzaga and our connection to diversity here in Eastern Washington. And students can come in with pride knowing that they have now a connection to Carl Maxey's legacy. And his family, Carl's family, his sons, came to an unveiling of new artwork remembering Carl in our Center for Civil and Human Rights, and are also very supportive of the program.
Great. Well, thank you for that.
Thank you. Any other comments? I also want to say a big thank you to the Dean about the Catholic Charities Immigration Project in Spokane. It's a very needed, we have a lot of legal deserts in our states, and immigration is an issue in Eastern Washington. We have a lot of immigration attorneys in Central Washington, but we have very few in Eastern Washington, especially that will help the people that could not afford to pay. So this is a big deal. I really appreciate that, Dean Rooksby.
Thank you.
All right. In the absence of any other comment or questions, we will let the Dean go and switch back to Patricia Lally to talk about the Racial Justice Consortium Action Plan feedback.
I appreciate it. Thank you, everyone.
Thank you, Dean.
Bye-bye.
Bye.
Thank you,
Bye.
Francis. Hello, everyone. And thank you for inviting me. Thank you for allowing me to share the work of the Racial Justice Consortium. And so I am ready to start. If I may share my screen, I have a very short PowerPoint. One of the things that I realized is that we've been doing some of these Racial Justice Consortium updates where the organization has had more information about the process, about what, who, who participates within the consortium, what our work has been. And then when we've gone out for these listening sessions, we realize that some organizations don't have enough of the background. So I've prepared a short PowerPoint that allows the viewer to learn a little bit about how we came together and what we've been doing. And so I will share my screen yes, I can do that. And so I'm going to just jump up to the top. Oops, sorry about this. And here we go. Okay, whoops, wrong PowerPoint, excuse me. Could have sworn I picked the right one. Just finished doing a training yesterday. Here we go. So, slideshow. All right. So this consortium has been working hard since March of 2021. And it really came about because of the Supreme Court's call to action in a letter that they wrote on June 4th, 2020. It was a bold letter. It was an honest letter. And it basically said, we're all accountable. We're all accountable to recognize the need for justice, the need for reform, the need to understand how we are responsible collectively and individually for eradicating racism in our system, in our judicial system. That letter came out in June 4th, 2020. And just a few months later, they began to work on what does it look like to go from the desire to eradicate institutional racism within the justice system, within the Washington state court system. That desire, how do we actually put legs on it? What's the mechanism to move forward? And so this consortium, which is comprised of judges, attorneys, court staff, law school, community advisors, and those with lived experience, was one of the action steps that came out of that bold letter, with the goal of building a roadmap to justice in each and every instance and in every courthouse in Washington state. That sounds like a pretty large endeavor. And we began that process with a series of trainings and facilitated discussions that allowed us to create our own circle of belonging, to understand what it means to belong and also what it means to be othered, and how othering is really the harshest form, how racism is the harshest form of othering. We looked at racial bias. We looked at the attributes of white dominant culture. We took a look at privilege and oppression, specifically about how it was going to play out in this group, how power was going to play out in this group. And we came to this hard work. People came ready to be vulnerable and courageous, which is what we needed. Only then were we able to move forward with implementing our racial equity toolkit as we looked at what were the areas of court reform and how would we inform ourselves in order to make the needed recommendations to develop strategies for particular areas. Excuse me 1 second, I'm trying to find my arrow forward. Thank you. So I just wanted to add this one message from the author of My Grandmother's Hands, that we will not end racism by trying to tear it to pieces. Instead, we can offer people better ways to belong and better things to belong to. And that really epitomizes the work of this group. The group was careful to not go in every possible direction. They chose 6 areas in which to inspect, in which to explore at a deeper level. The first was on how do we cultivate spaces of belonging and build the racial equity muscle necessary to do this work. And from there, they looked at these other substantive areas: child welfare and the dependency system, youth justice, sentencing, legal financial obligations, and then reentry. We followed this timeline, and we are today at number 6. We are in the process of, we have determined strategies, and we're looking at what structures of accountability will be necessary. And one aspect of accountability is to return to all of the individuals and the organizations that came forward to help us understand what reform would look like, where to start, how to prioritize reform, but also to all of the stakeholders that we've identified, including yours, of this is what we've come up with. What do you think about it? What did we miss? What do you think we should emphasize? And any critical feedback that you might offer. The action plan still is in its draft form as we take in information offered by our critical stakeholders so that we can perfect this document and move forward. We have an action plan, and we also have a website, and we invite you to visit both our website, and one of our supports was Debbie Espinosa, whose work with LFOs has been particularly noteworthy. Living with Conviction, an organization whose advocacy on LFOs has been so powerful in so many ways. And not only is she an attorney, an advocate on LFOs, helping to support this amazing nonprofit organization, Living with Conviction, but she's also an artist. And you will see some of her graphic design and artwork that made this plan and our website so beautiful. She's not here today, which makes me happy that we're recording this session as we gather hopefully some of your input. I'm not going to download the action plan because what I found is that it does not move forward as we're looking at various sections of the action plan. Let me share with you though what the action plan is not. The action plan is not a study. It's not a deep dive into years of data. The action plan is intended to be a nimble tool that users of this action plan can go to as a reminder, as a guide to what the recommendations are that we're prioritizing for this first year, and what we are responsible for and how we're going to do it. It was clear to the consortium that we could do many things, but if we attempted to do many things, we would not do much, and we would not do it very well. This action plan is very specific, and the recommendations look like this that have flowed from this action plan. The areas of these strategies involve education and training, advocacy, the implementation of new programs and policies, some that have already begun and some that we want to expand and further. And then what does it mean to measure and to evaluate, to hold ourselves accountable? We know that many groups come together and have great ideas, develop strategies, and these strategies become almost as precious as their firstborn children. And we become defensive, and we want to protect our strategies. But the reality is we have to put them up to a bright light. We have to go back to our community and ask, are these strategies changing? Are changing the outcomes that we want to see? Are you feeling the impact of these strategies? Because if we're not getting them right, and I suspect that we will not get not all of our strategies will work, is what kind of measurement and evaluation tool will we put in place that catches that so that we can renew our efforts to create more just outcomes in every courthouse and in every instance. So in the area of belonging, these were the three strategies, the three areas that they wanted to zoom in on. One, to make courthouses more humanizing and accessible, to make documentation more accessible to users of the court, and to remove barriers to accessing the court, and community resources. Now, I'm just giving you the bold outline for each of these three strategies. And if you go to the action plan, underneath these three strategies are different ways that we make good on each particular strategy. Katie Loring, one of the participants of the consortium, has actually taken on this concept of belonging, this notion about what it means to belong, that when you walk into this courthouse, you feel like you belong, your voice matters, you're going to be treated fairly and justly. She has actually gone out and has worked with other judges in other commissions and other associations to actually put meat on this strategy of what it means to belong, and provides tactics for each of these that make these steps more meaningful. Our second area of reform is child welfare and dependency. And these are the three reform areas that we have chosen. One that involves advocacy. And we learned that judges are tentative about advocacy, that they worry about what advocacy how that might trip them up, hold them in, that leads them to feel like, do they have the opportunity to be keen advocates? And also, how do we link arms with those groups, both in the community and also happening with other agencies, to actually join hands and not do advocacy on our own, but to make our advocacy part of a movement? We talked about prioritizing family preservation, family supports, and family connections. This is some of the work that AOC is actually expanding with their family treatment courts and digging deep into what is keeping them from being as effective as they need to be. We also are addressing, I'm also addressing the capacity of court players to reduce or eliminate racial bias. Youth justice. There's a lot of work happening in the realm of youth justice, but a lot of that work is happening in particular areas, in particular regions of Washington state. So how do we expand that across the state, and what are our obstacles? So we are looking to examine youth systems to ensure that they're designed around recent brain science specific to ACES. Absolutely to reduce the use of detention and change probation practices. We know that in certain areas that work's already been done. How do we ensure that it's happening across the board? And to examine the ways that the juvenile justice system reinforces the expectations of adult systems. Moving on to sentencing is, how do we expand the use of more incentive-based and diversion models, to address behavior and the underlying needs of individuals? How do we expand the successful rehabilitative elements of juvenile courts to adult courts? What are the promising, innovative things that we've experienced in juvenile justice, and how do we adapt that to to adult courts, and to interrogate the ways that plea bargains are efficient tools in upholding systemic racism. Once again, this work's happening in other areas. Great work is happening from the Minority and Justice Commission, from the Gender Justice Commission. How do we join hands and actually support one another in our various action plans that each group might have? Finally, with LFOs, the desire to eliminate completely LFOs was a very popular view with the consortium. But we also recognize that there are groups, courts that are not quite there with eliminating LFOs in their entirety. And so we added this a provision that victim restitution is something that we might have to work to further our understanding about victim restitution, and it allows court stakeholders to get behind our desire for this strategy while recognizing that we are still that there's still a journey on this particular issue. We definitely had a consensus about eliminating incarceration as a penalty for non-payment and eliminating LFOs for juveniles altogether. And then finally on reentry. Reentry was a challenge because courts might say that once the sentencing is completed, that their authority and jurisdiction is very limited. And this is an area where we need to say, how do we partner with other departments? How do we partner with community efforts to ensure that we work to expunge criminal records for youth and adult populations? Perform, before release, provide a reentry toolkit and a corresponding navigator. And before release, provide incarcerated individuals an opportunity to engage in comprehensive shared family support sessions or trainings. These are just the 3 strategies in every area. I'm hopeful that by the end of next year, this same group will look to see what they have done, where they need to struggle more, work harder, and then also how do we incorporate the other strategies that the consortium has developed. The group actually had close to 100 different strategies over these 6 areas. And so there is work for a lifetime here. And we're going to hold ourselves accountable for these 18 strategies this year. We have received feedback that we need to provide more detail about the implementation plan. Many of you know Cynthia De Los Trinos, who is now the Associate Director at AOC on Court Innovation. We are working internally, and for the remainder of my time with AOC, we are working internally to examine the resources that we have already to ensure that implementation is robust, to ensure that we are providing the resources to the consortium members so that they can do their work, and also to provide an accountability system so that when people get busy, they forget and maybe perhaps put this action plan on their back burner. How do we keep it up front? How do we keep our stakeholders engaged? How do we honor those individuals and organizations who came to us at our request to provide their lived experience? And so this is about rolling up our shirt sleeves. We know the work has already begun in many areas. We also know that we're going to have many obstacles and that we're not going to get it right. So how do we walk forward despite the fact that we will have these obstacles? Maybe we're already experiencing them. And how do we keep accountability at the forefront? So that's a little bit more background. Members of the consortium are here today at your own meeting. I encourage those consortium members to share their thoughts and also their concerns, their desires, and mostly, how do we connect with you in your work so that we don't work in parallel, but that we work together. So thank you for allowing me to share this PowerPoint with you. I'm going to turn it back. I'm going to turn it off and rejoin your room and listen.
Thank you, Patty. Any comments for Patty? Oh, Cindy, I see Cindy and Terry and Jim. Let's start with Cindy.
Thank you, Francis. Thank you, Patricia, for your presentation. Just one quick question. So what sort of collaboration or overlap do you have exactly with the Minority and Justice Commission? Because I'm a little confused because the mission of the MJC is to identify and eradicate the effects of racial, ethnic, and cultural bias in the state court system. And your website talks about ensuring fairness, equity, and justice in every instance, in every courthouse, in every county. So they're really similar. So I'm just wondering if you could talk a little bit more about that.
Great question. We're working really closely with the Minority and Justice Commission. When we started, and there are members of the Minority and Justice Commission who are also working on the consortium. We are joined in many respects at the hip. So for example, on education and training, how do we create training that is accessible and yet powerful? How do we acknowledge that our trainings are across the board, racial equity trainings are highly ineffective? How do we just admit that and then begin to think about what kinds of trainings have the potential for greater effectiveness? And that is something which the Minority and Justice Commission is working on. They have a committee working on that. And how do we join that committee to ensure that training, including training on cultivating belonging, which is showing huge promise across the board with groups working on racial equity? How do we inform one another and move forward? What is particular about this consortium is that it is intended to hold judges accountable. It recognizes the power and the authority of judges in their courtroom, at their courthouse. How do we give them specific direction and strategies in which to employ to best move forward? The consortiums might have a more global view, and the consortium, did I say that right? The commission, the Minority and Justice Commission, might have a more global view about their work. And this consortium is attempting to be very specific in the work that it will do.
Thank you, Patty. Terry and then Jim.
Good morning. Thank you very much for your presentation. I'm on the ATJ board, and I'm one of the tech nerds, and I'm the co-chair of the tech committee. And under your first category, belonging, I would just encourage more consideration, less consideration of a courthouse as a brick and mortar place and more consideration of a courthouse as a place in the internet where people can access. So that, I mean, the three recommendations have to do with being there, but being there is now being here on your phone, right? So I think, and I apologize to Sharif, he's heard me say this several times, and but I would just encourage consideration of an internet-based solution to some of these problems.
Perfect. Thank you.
All right. Jim?
Thank you. I'll be brief. I just want to recognize Patty's amazing efforts in leading a community of people who didn't even know what this project was about from the start, many of whom have never been immersed in conversations about race or self-conversations about race, a number of whom have traditional reactive responses, particularly who kind of look like me. And at all times, Patty was grounded in, as she started today, the Supreme Court's directive and commitment. Very even-handed, very steady. She and the team really, this was far more difficult than herding cats. And I'm really grateful. Nothing's perfect. The report's not perfect. A number of us were critical about some components of it. But at the end of the day, for our courts and this committee and the commission and the Supreme Court effectively, since all of this is under the Supreme Court, to do and to commit to what the resulting plan is an extraordinary statement in and of itself. So thank you, Patty, so much.
You're very kind. Thank you, Jim.
Thank you, Jim. I believe also the ATJ board nominated a member of Just Lead to represent the ATJ board on the Racial Justice Consortium. And I believe they also have some comments. I'm asking Bonnie if you could provide that in the link in the chat, as a link in the chat. It's also included in the material, which I believe they also make some comments on recommendations on this action plan that would go a long way in helping us to on this issue. Bonnie, can you provide a link in the chat for that?
Yeah, I don't have it with me at this moment. I'll follow up with Patty.
Okay, all right. Thank you. Any other comments for Patty? All right, thank you, Patty.
Keep up the. Just wanted to say, keep up the great work, Patty. We commend you and your team for all that you're doing to bring change. It's really impressive, and we thank you for that.
Thank you.
Yes, I echo that. Thank you, Patty. We appreciate you. All right. Thank you, everyone. We now go to the next issue on the agenda, which is Judge Keenan is going to present the ATJ Board 2-year priorities review report. Judge Keenan?
Yeah, thank you, Francis. I don't think I scrutinized the agenda closely enough because I thought this was on for an action item. Because I think the board has to adopt the recommended new.
That's correct. We can make that correction.
Okay. So we convened this group to check in on our progress on our 2020 through 2022 priorities and assess where and what might need to be changed. So just to back up for a moment, in late 2019, we convened a group that I was a member of as well to do two things: assess the board's progress in its prior set of priorities, just to see had we accomplished what we set out to, and to propose a new set of priorities. And we had board members and we had non-board members on that group with a lot of great support from our staff, so Bonnie and Diana. And back then we circulated, so this is late 2019, we circulated a draft to our alliance leaders. We took their feedback, and then we refined and approved a set of priorities that would take us through this year, that would take us through the end of 2022. But that was the end of 2019. And so at least two significant things took place not long after we adopted those priorities. There was the pandemic and there was George Floyd's murder. And while we did not let our already adopted priorities stop us from addressing the needs that were presented during the pandemic and everything that happened and the work that our board needed to do after George Floyd's murder, we still thought it was important to do a midpoint assessment of how we were doing on our priorities. And so we've spent the last few months on that. It was important for us to look at a lot of the really significant work that had been done in recent months by other organizations. So for example, we combed through the Gender and Justice Commission's new report, 2021, How Gender and Race Affect Justice Now, Legal Counsel for Youth and Children's report, which was called Invisible and Inaccessible: Young People's Perceptions of Civil Legal Aid. The work of the task force on race in the criminal justice system 2.0, a report from the White House interagency roundtable, legal aid interagency roundtable called Access to Justice in the Age of COVID-19, and a lot of other sources. And we consulted with something that we did not have in 2019, which is our community advisory panel, to bring in their important perspectives. And the new document is in the materials circulated to the community in advance of today's meeting, although it was circulated late, and that's on me. And we've included a lot of information about our progress in that document. We've included some new implementation goals. And so one significant implementation goal, just as an example, is working to ensure that unrepresented litigants have equitable access to remote proceedings. That was something new resulting from the pandemic that we had not planned for when we adopted our current priorities in 2019. And given the work that we put into this assessment, we're actually proposing extending this revised set of priorities through 2023. And so procedurally, I don't think this comes as a motion from a standing committee, because I think this group was ad hoc. But what I'd envision is a motion from an Access to Justice board member to adopt the priorities, hopefully a second, and then we get it opened up for discussion by anyone in the meeting before a vote of the board, with one significant caveat, and that is that I have a guardianship hearing at 11 a.m. And so it could be that I might need to drop out, but that wouldn't prevent the board, that wouldn't prevent discussion in the board from moving on an action item. So I'll stop there.
Thank you. I think some of the committee members can step in for you if you need to go. But I'm going to request two more action items. One is to bring it as an action item, to change it from a report to an action item, and the other one is to adopt the report. But first of all, let's have any discussion on these priorities.
Francis, I would think procedurally the better course would be get it moved and seconded and then open it up for discussion.
Okay. Okay. Yeah. Okay. Let's do that. Yes, Terry, go ahead.
I move to make it an action item.
Second. Okay, Michelle. Okay, Mike Chin, second. All in favor, aye. All right. SP, I can hear you. Okay. So I believe 1, 2, 3, 4, 4. Yay. I believe 2 absent. No, 1. SP. All right. Bonnie, did you get that? Yep. Thank you. All right. Now let's go to the discussion phase. Terry, go ahead.
I move that we vote on the priorities.
All right. Second. Michelle
seconded. Yeah.
Michelle seconded. All in favor, aye.
Aye.
Aye. All right. Bonnie, you got that?
Yep.
Thank you. All right. I believe, Jim, did you want to make a comment on these priorities? Okay. All right. Thank you. Thank you, Judge Keenan. You can go to your hearing.
Yeah, my comment was in the chat. It's extraordinarily descriptive of so many powerful initiatives grounded deeply in the boards and the alliance's equity commitments. So I think it dovetails very nicely with the Supreme Court's expectations of all of us, and really great work.
Thank you, Jim. Much appreciation. All right, thank you, Judge Keenan. You could go to your guardianship.
I think we need a vote on the motion, which was
we did. Did we vote on adopting the priorities?
Yes, that's
Okay.
what we just did.
Okay.
We did
all
the
right.
two motions.
I'm
back
sorry.
to back.
I heard discussion after that, and okay. All right.
Yeah.
All right. Great. It's adopted. Wonderful.
Don't worry, Judge Keenan is adopted. I know you've been working so hard on this. Thank you.
We all have. It's been a fantastic
Yes.
group. So
Thank you. Appreciate it. All right. So we will now go to the liaison report. I will let Terry go first because my report on the bar structure will be in the form of a video, and I believe Bonnie has to be ready for that. So if you want to go ahead, Terry, to present the report on the GISC.
Sure. Though now I can't wait to see the bar structure video. So thank you, Francis. Very briefly about the JISC. Unfortunately, I was out of town and missed the meeting. And weirdly, the JISC meeting was not recorded by TVW, which is odd since they tend to record all the committee meetings. So just the issue right now, I think after the legislative session, is funding. The legislature funded the 1 year Tyler costs for the CLJ-CMS, the Courts of Limited Jurisdiction Court Management Services, so that there will not be user fees for the for e-filing, and that has been kind of assured, kind of in a light way, assurance, given that that's going to be ongoing funding. And that was a question that Jim had raised a while back, to draw our attention to: is this a one-shot deal, or is this ongoing funding? People seem to think it's ongoing funding. Of course, I'd like to see that in writing. There's also, the legislature gave $17 million to
Terry,
yes,
Terry, can I just interrupt really quickly?
absolutely.
This was a line item in the budget.
Yes.
I can tell you, I've got the working papers. I'll let you know.
Okay. So the legislature also, I guess under the stewardship of Senator Peterson, gave $17 million to buy out the Judicial Information Systems account. Those of you who may know, unfortunately in Washington, we fund the court technology through traffic infractions and speeding tickets. And you can imagine that during the pandemic, when people were working at home, there were fewer people on the roads, fewer traffic tickets, and there was a $17 million shortfall. So the legislature has bought that out. That's now zeroed out, and which is a good thing. Obviously, the next best thing would be to create a system of funding court technology that doesn't rely on traffic violations and traffic tickets, but rather on dedicated state funding, one step at a time. Otherwise, the other technology things, House Bill 1320, which was the major rewrite a year ago on the domestic violence protection orders and all of the protection order statutes, and then 1901, which is the trailer bill, have created a lot of technology issues for the courts in how to implement the things in those bills, such as notifications to people who are protection order petitioners that the guns have been removed from the house, or that the respondent has been served, kinds of notifications that we don't right now have through our court management systems. So this could be a substantial driver to increasing technology for users in terms of email notifications, text notifications. All of that requires technology changes. So that's what's on the horizon in terms of technology.
Thank you, Terry. Any comments? Any comment for Terry on the liaison report? All right. We're going to go next to the WSBA Board of Governors and the Bar Structure Work Group. This information I want to provide to you is not included in the video that we're going to play because this is a recent information. The U.S. Supreme Court on the 4th of April this year denied cert for 3 cases challenging the integrated bar structure. Taylor v. Eads, which is I believe a Michigan case. Shell v. Darby, which I believe is an Oklahoma case, and McDonald v. Borunder, Firth, which is a Texas case. So then last Friday, the 7th U.S. Circuit Court of Appeals upheld the mandatory structure of the State Bar of Wisconsin. Terry was quick to send me an email on that, rejecting claims that compulsory membership and dues violate attorneys' constitutional rights by forcing them to subsidize political speech. In line with 4 other appeals courts in other jurisdictions, a 3-judge 7th Circuit panel unanimously ruled that the 2018 U.S. Supreme Court in Janus decision did not expressly overrule its 1990 decision in Keller. So, however, the lawyer for the plaintiff in that case says that he will be asking the U.S. Supreme Court to take up this issue. So that's the latest. Now I'm going to have, please encourage you to listen to this small video. It's a 10-minute small video on this issue. Bonnie, are we ready for that?
I think I'm going to share my screen.
Oh, thank you, Diana.
Sure. So let's see here. Okay, can everyone see that?
Yes, thank you.
Okay. This is the right one, right?
Yes, that's the one.
Hello, my name is Brian Tollefson, and I am your Washington State Bar President for this year. I'm requesting about 10 minutes of your time today to learn about a study process underway that might significantly impact the structure of the Washington State Bar Association and how it serves our members and the public. I know you are busy, but your feedback will weigh heavily in the outcome, and we want to make sure that you understand what is at stake. It is a complicated subject, but here's a quick overview. The Washington State Supreme Court and the Washington State bar leaders have been keeping close track of federal litigation concerning the constitutionality of the integrated bar structure, which is the structure of your current Washington State Bar Association. Now, in light of these recent developments, the court has asked the Washington State Bar Association Board of Governors to convene a study process and to make a recommendation about whether we must, or perhaps more importantly, should change the historic structure of our State Bar Association. Now I'm going to turn it over to our Executive Director, Tara Nevitt, to give you a little bit more history and context about what's going on. And after that, I'll return to invite you to be involved in our study process.
Let's begin with an understanding of the bar's current structure. Across the United States, there's significant variety in terms of the structure, scope, and functions of bar associations. However, there are 2 primary models: the agency or voluntary model and the mandatory or integrated model. Under the agency model, the regulation of the practice of law is carried out directly by the state Supreme Court or an agency that reports directly to them. And participation in the statewide bar association is typically voluntary. In an integrated bar association, like the Washington State Bar Association, the bar administers regulatory functions on behalf of the court, in addition to acting as a professional association for lawyers and other legal professionals. So the Washington State Bar Association is administering admission to the practice of law in the state, including the bar exam and the law clerk program. It also administers the discipline system for legal professionals, and it regulates mandatory continuing legal education. The bar also administers bar sections and provides legal education, practice management, and ethics advice, as well as wellness programming. The bar also has programs focused on promoting a legal profession that is diverse, inclusive, and welcoming, and a justice system that is accessible and equitable for all. This breadth of programming is all in furtherance of our mission to serve the public and the members of the bar, to ensure the integrity of the legal profession, and to champion justice. Membership in the integrated bar is mandatory, and it is the mandatory association that gives rise to some important legal questions. When the Washington Bar Association was established in 1888, membership was voluntary, and regulation of the practice of law was carried out directly by the court. In 1921, the State Bar Association of North Dakota became the first legislatively created integrated bar, and the model quickly caught fire, with 9 other states following suit between 1921 and 1932. The integrated bar model came to Washington in 1933 with the adoption of the State Bar Act, which assigned regulatory functions to the organization and made membership mandatory. One of the benefits of this model was the promise that the regulation of the practice of law would be funded by the profession itself. The Integrated Bar Association has long been subject to legal challenge, and for 30 years, 2 Supreme Court cases have provided the framework for our current structure. In 1961, in a case called Lathrop v. Donahue, the U.S. Supreme Court held that states may constitutionally require membership in a state bar to further their legitimate interests in raising the quality of professional services, even if the organization also engages in some legislative activity. In 1990, in a case called Keller v. State Bar of California, the U.S. Supreme Court again upheld compelled association in an integrated bar. But this time, they said that while a state bar may constitutionally fund activities that are germane to its purposes from mandatory dues, it may not use mandatory dues to fund activities outside of those areas. In Keller, the court gave us a slightly new statement of the justification of an integrated bar, which is to regulate the legal profession and improve the quality of legal services. As a result of that case, the Washington State Bar Association adopted a Keller deduction procedure. So annually, we identify any activities that could be construed as non-germane to the purpose of a state bar, as set forth by the court in Keller, and we offer members the opportunity to take a Keller deduction from their mandatory license fee. 2 things important to note. First, the activities of the Washington State Bar are also governed by General Rule 12.2, which sets forth the activities the bar may engage in, as well as prohibits us from taking positions on political or social issues which do not relate to or affect the practice of law or the administration of justice. While not identical, this standard is similar enough to the Keller language that there is a very small universe of activities that are allowed by court rule but cannot be funded by mandatory license fees under Keller. Second, the bar's bylaws require that we take a conservative approach in calculating the Keller deduction, meaning that if there is any question at all, we resolve it in favor of the member and include the activity in our calculation. So we've been an integrated bar for 90 years and operating under Keller for 30 years. What's leading us to examine our structure now? The answer is a 2018 U.S. Supreme Court case called Janus v. AFSCME. in which the court directly overturned the 1977 decision of Bood v. Detroit Board of Education, when it held that the First Amendment forbids the government from requiring their employees to pay union fees. Why does a union case matter to integrated bars? Because the legal analysis for compelled payment of union fees is intertwined with the legal analysis for compelled payment of bar fees. In fact, Abood formed the basis for the Keller case. Immediately following Janus, the Washington Supreme Court created a work group to study the decision, other bar structures, and the structure of the Washington State Bar Association. Following that study, the majority of the work group concluded that the model did not require any changes and should be maintained. The state Supreme Court accepted that recommendation. So why are we looking at it again? Following the Janus decision, there has been a flurry of legal challenges to the integrated model. Decisions have been issued in the 5th, 6th, 7th, 8th, 9th, and 10th circuits, and a split in those decisions has developed, making it more likely that an appeal might be accepted by the U.S. Supreme Court. At a minimum, if a change to our structure becomes required, we would like to be prepared. And we are also considering whether any changes to the structure might be beneficial to the mission. A few integrated bar associations have made changes to their model in the past decade, most notably California. As the Board of Governors takes up this study of the bar structure, we hope that you will follow along and engage with us. Let us know what activities of the Bar Association you value and help us think about whether those might be strengthened or weakened by a change to our structure.
Thanks to Tara for all of that information, and thanks to you for the time you've spent so far on this important topic. As Tara mentioned, one of the most important considerations for the Board of Governors as we study and consider changes to your state's bar structure is your input. We are holding several full-day public meetings now through the end of August 2022, when we will return our recommendation to the Washington State Supreme Court. Some of these meetings are specifically devoted to receiving comments. We sincerely hope you will take the opportunity to participate, either at an upcoming meeting, through an email or phone call, or even by inviting us to come to one of your meetings or events to have a conversation. You can find out more about all of this information by visiting the Washington State Bar Association website at WSBA.org and by clicking on the main image at the top of the page. Thank you for your time and consideration. The Washington State Bar Association is our organization, and its history and future are important to us all.
Thank you, Diana. That should be enough. Thank you. Any question? The next meeting for the structure, for the ethos meeting is Saturday, May 21st. Saturday, May 21st. All meetings are on Zoom, and you can join in at any place, at any time. Please feel free to join the conversation. It's very important because our Access to Justice Board is housed within the Bar Association. And this is very important to the future of access to justice also in our state. Thank you. All right, any question, comments? Yes, Jim, go ahead.
I've probably said this before, but this is of course not the first time the bar has considered these issues. I guess this is a little bit more urgent than the time that then Chief Justice Fairhurst was sponsoring a similar conversation. During that conversation, both the King County Bar Association and the Office of Civil Legal Aid expressed very, very clear and complementary positions on the need to and urgency of moving away from the integrated bar and moving toward a trade associational entity and a regulatory entity. We've been asked and we have agreed to allow the State Bar News team to include the King County Bar's letter and Okla's comments relative to that letter to be included in the next Bar News. I don't know when it's coming out, but our positions have not changed.
Thank you. Thank you, Jim. Any other comments? Diana?
I was just going to share, because you had shared all the different meetings that are coming up, which anybody is welcome to come to any of those meetings. But I do know the July meeting is the one where they're really hoping to hear from alliance organizations, the Access to Justice Board, the minority and bar associations. So I'm mentioning that now in case you and the organizations that you work with want to, talk about it, see if you have any collective opinion as opposed to your own individual input. So you kind of have that in your mind of July would be the meeting that you want to shoot for to share that input, whether you come to the actual meeting. And then of course, along the way, you're always welcome to just share it via email too. You don't actually have to come to a meeting, but just wanted to point out the July meeting date.
And that will be on Saturday, July 23rd. I believe all meetings start at 9 a.m. Diana, am I right? Yes. All right. Thank you, everyone. Any other comments? I think we can move to the next issue on the agenda, which is to take our EJC report. It's Kara and Caitlin. I saw Caitlin.
Yes, I'm here. Sorry, I turned my picture off because I think sometimes it's easier for you to hear if my picture's off, and I don't know why that is. And Kara Masters is sorry she couldn't join us this morning, but I will give you our brief report. And the headline news is the Legal Foundation has hired a new director of communications and advocacy who will spearhead a lot of our communications efforts, as well as lead the Equal Justice Coalition staff in the coming years. The new person is Alex Diaz. She joins us from Disability Rights Washington, where she's been for 4 years, most recently as the communications coordinator. And she also recently earned a master's degree of communication with a focus on communications and networks. So we were lucky to receive an abundance of applications for this position, but we think Alex is going to make the work sing as we think about new strategies for telling people about the importance of civil legal aid. And Alex is going to start May 23rd, and I imagine we'll do a tour for many of you to introduce you to Alex and figure out how she and all of our stakeholders are going to continue the work of getting the message out there. So, yay. And thanks to those of you on this call who helped with the, sort of selection vetting process. That was invaluable to get your input. I think the only other big updates from the Equal Justice Coalition are to thank the alliance partners who shared their feedback with us to the Office of Civil Legal Aid to help determine priorities. It was really great to see your input, and we look forward to helping move your request forward to the extent that we can. OCLA has also invited EJC to submit a response. Jim, I apologize. I think the deadline is 6:15, but we plan to submit something. And again, thank you for the opportunity to comment. And
but the deadline of 6:15 is for the vendor rate adjustment that for the programs that are funded through LFW, not because the other deadline was April 30th.
Anyway, thank you for the opportunity to comment, and we do plan to submit something consistent with your request that you sent us.
Thank you, everyone. Oh, sorry. Go ahead, Caitlin.
Well, I didn't know, just in the interest of time, I know we're coming down on the 11:30 hour. Do you want me to just give you the LFW and campaign updates?
Yes, yes.
All right.
Please.
Okay, well, we've had a busy month. Just on Wednesday, we gave our annual report to the Supreme Court, and it went well, and had a couple of interesting questions that I think I'll share with Francis and Diana and Terry. The other big news was that the deadline for our race equity grant program was April 15th, and our community-based panel will convene later this month and make 8 $40,000 2-year grants, which we're really excited about. The increased amount of funding and increased amount of time that this gives our partners to work with. Some of the applications we received were phenomenal. One thing that I felt fortunate to get to do was we had an application made verbally in Spanish. And then via Zoom, we had an instantaneous interpretation. So the folks on the phone who spoke Spanish and the folks on the phone who spoke English got to hear, in instant time what each other were saying and hearing. And, it was one of the coolest uses of technology that I've seen this year. And so I was really, it was just a wonderful approach. And if anyone is interested in adopting that, we have some new experts on the LFW team who could let you know how that works. I also wanted to let you know that our fundraising efforts are in full on mode. This is Beer and Justice season. There's a full calendar of events at the legalfoundation.org/campaign page. If you want to see where we're headed out, if you'd like to have a beer and learn more about equal justice on June 1st, that's sort of our kickoff date, and we'll be in Everett, but there's lots of other communities around the state that we plan to visit. We've set a date for the upcoming Goldmark luncheon. It's going to be February 17th, 2023. Hypothetically at the Westin in Seattle, but we're going to have for sure a remote option. And, we're looking forward to potentially a hybrid model, but we're going to, wait and see. We have a few months to see how that goes. And the last thing I wanted to let you know that, a big initiative of the the Endowment for Equal Justice is what is now becoming an annual trip to Montgomery, Alabama. And our crew of about 30 donors and board members got back at the beginning of April. The goal of this trip is to, more deeply understand slavery and the history and the role of civil legal aid in dismantling these, racist systems that hold us back, and what we all can do. And it was, by all accounts, a wonderful trip. And the next time we issue our newsletter, I know we're going to have a lot of commentary from people who participated, but so there you go. And that's my report in a nutshell. Thank you so much for giving me this time.
Thank you, Caitlin. I just quickly want to plug the Beer and Justice in Spokane, which is going to be next week, Thursday, and then the Beer and Justice in Vancouver, where I will be speaking on June 23rd. I invite all of you to join me there. All right, thank you. We now go to the federal report. Cesar and Abby.
Hi, good morning, Francis. Good morning, everyone. I don't have any specific updates on federal funding beyond what was reported last week and what appears in the minutes. The Biden administration is recommending $700 million for the next year for the Legal Services Corporation, which is a high watermark. The Legal Services Corporation is requesting over $1 billion because of the historic underfunding and failure to not only maintain and increase funding as needed, but also address the rising need and the challenges facing poor people in accessing civil legal aid. I was asked if I could briefly comment on the most recent Legal Services Corporation Justice Gap Report. And I'm going to share a link to the executive summary, but not a surprise. The Justice Gap Report by the Legal Services Corporation, which was just released, speaks about the tremendous gap in the resources available as surveyed and through the legal services programs and the need of low-income people. The headline really is that low-income people facing civil legal needs do not get legal help for 92% of their substantial civil legal aid problems today. As we saw in our civil legal needs study, which is also an incredible comprehensive report, we're talking about individuals who are 74% of low-income households experience at least one such legal problem per year, and then 39% of them experience 5 or more, again, echoing very much along the lines of our reports here in Washington.
Thank you.
I'll put my link in the chat, and so you all can peruse the executive summary, and I will go with that.
Thank you, Caesar. Jim, state report. You're mute. You're mute.
Which is a good thing most of the time. Anyway, in the interest of time, I actually put a bulleted version of our update. There's a ton of stuff going on, including implementation of multiple new programs and provisos. We have 2 NOFAs out. We have 2 more that need to be issued. We are also in the process of determining both the focus and magnitude of fiscal year biennial 24-25 budget requests. We have multiple programs that have huge bow waves to them that are going to require significant amounts of new funding. We also have to make sure that we are addressing the vendor rate adjustment issue for both NJP and the state share of vendor rate adjustments for entities that receive funding through the NJP LFW subcontract, mostly pro bono programs and a few direct service providers. There's just a lot of stuff going on here. We'll be soon. Well, we've hired 3 new staff people, 2 for the children's program, 1 for the Right to Counsel program. We have multiple additional hires that we have to make in the coming months, including an agency director of operations. Stay tuned for that one. Yeah, it's heady times here.
Thank you, Jim. Appreciate that. Any comments for Jim, Abby, Cesar? Any comment for them? All right. All right, thank you. The next meeting, ATJ Board Committee schedules, the DISCO meeting is going to be, as usual, 4th Monday of every month. The next meeting is May 23rd. Technology Committee, 3rd Tuesday of every other month. Next meeting is going to be June 21st. Rules Committee, 3rd Tuesday every other month. Next meeting is going to be May 17th. And the next ATJ Board meeting is going to be July 8th. Any other comments? Any other announcements from the community, from the ATJ community that we need to make? In the absence of that, I give you 1 minute back this month. Thank you. Have a nice summer. Bye.